Good afternoon, everyone. Thank you for joining us today for today's online talk, which will be starting shortly. For those of you who have joined us early, thank you for waiting patiently. While we wait for the session to begin, we would like to share a short video about our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Disputes over Maintenance Charges in Strata Developments. My name is Kirbashini and I'm a Senior Associate with Mao & Kwai & Associates, and I will be your moderator for today's session. Before we begin, allow me to briefly introduce our firm and the work that we do. Mao & Kwai & Associates is a mid-sized law firm founded in 1985 by Datuk Mao & Kwai. Our able team today consists of 35 lawyers and a support team of 29. Following his retirement from the Court of Appeal bench in 2015, Dato' Ma now serves as a consultant with the firm. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment, industry relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus area, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require specific legal advice in relation to your matter, please contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. We have one speaker for today. Allow me to introduce our speaker, Ms. Rachel Ng. Rachel Ng is an associate at Mao & Kwai & Associates. She was admitted to the Malaysian Bar in December 2021. Rachel graduated from the University of Northumbria, Newcastle in 2019 and subsequently completed her Bar Professional Training course, BPTC, at the same university in 2020. Her areas of practice include land disputes and strata management disputes. In today's talk, Ms. Rachel Ng will enlighten us on several key issues concerning maintenance charges under the Strata Management Act, including how charges must be calculated proportionate to share units, imposition of single rates versus multiple rates, and the available methods to recover arrears in charges, and the proper usage of maintenance charges and sinking fund contributions. We will then conclude with a Q&A session. If you have any questions, please feel free to type them in the Q&A chat box. We will address the questions at the end of the sessions. With that, I'll now hand the session over to Ms. Rachel.
Thank you, Kirba, for the introduction. As explained by Kirba just now, we will be focusing on 4 top points. The first would be the calculation of maintenance charges. So the calculation of maintenance charges for strata developments must be proportionate to share units. So what are share units exactly? Share units are the numbers which are assigned to each parcel by the land surveyor, which is used to determine maintenance charges, a sinking fund, and any other outgoings. The share units determine specific parcel is as shown in the strata register, and the share units must be allocated in accordance with the formula set out in the strata titles rules. For this, you can refer to the first schedule of the Strata Management Act. So for accessory parcels, they don't actually carry independent share units. The share units for your accessory parcels, such as your car parks, are assigned to the main parcel. So for the share units of accessory parcel, there is one case which discussed this, which is the 32 Square against 32 Square Sdn Bhd. This is a recently decided case in the High Court. So in this particular case, the management committee actually came for the outstanding charges from a parcel owner based on invoices which are issued separately for the main parcel and its accessory parcel. So in this case, the High Court held that the maintenance charges cannot be imposed separately on an accessory parcel. So if you look at your invoices from your management committee or from the JMB, it would show one single charge for the maintenance charges. It would not be separate based on your main parcel share unit. So whether the calculation of share units can be calculated according to per square feet or per share unit. So as established in multiple cases, a management body can only impose and collect maintenance charges and sinking fund contributions on a per share basis. So if your condo or apartment is still calculating your maintenance charges according to a per square foot basis, this is actually illegal. They are required to recalculate it on a per share unit basis and then issue the invoices to you. So the case which states that per share unit is mandatory is this case of Equity Settegah Sdn Bhd, which is decided at the Court of Appeal. So over here, the management committee commenced an action to recover outstanding charges which were calculated on a per square foot basis. The Court of Appeal held that the Strata Titles Act mandated that charges be calculated on a per share unit basis. So any other basis is contrary to the Strata Titles Act and thus illegal. Another case which discussed per share unit versus per square feet is Perbatu Square. This is also the same case which I mentioned just now. What happened here was that a portion of the outstanding charges claimed by the management committee was calculated on a per square foot basis. So here the High Court held that charges must be calculated strictly in proportion to per share unit, and thus the plaintiff's claim is dismissed. So a note here is that prior to the Strata Management Act, the developers are not obligated to impose charges on a per share unit basis during the developer's management period. So during the developer's management period, I believe most developments would be imposing maintenance charges on a per square feet basis, which is then recalculated to a per share unit basis. Another case which states that per share unit is mandatory is also a recent case, Fujin Hao and others against Sime Darby Brunsfield Holdings Sdn Bhd. So here, the parcel owners claim for outstanding charges against the developer for sums imposed during the developer's management period and the joint management body period. So here, the High Court held that under the Strata Management Act, JMB is required to impose charges on a per share unit basis. However, the developer was not obligated to impose charges on a per share unit basis during the developer's management period prior to the coming into effect of the SMA. Okay, so we will move on to the next top point, which is whether management bodies can impose single rate or multiple rate of charges, of maintenance charges. For maintenance charges, it is usually determined by the management body, and the rates are determined during the annual general meeting of the JMB or the MC. This is when you vote on the rate of charges to be determined during your annual general meetings. The charges, based on case law, there are different decisions from the court based on either whether your condo is still under JMB, which is the joint management body, or whether your condo is under the governance of the management committee, which is the MC. So during the JMB period, one of the main cases is this case of Muhammad Nazri against the JMB of Menara Rajawali. So in this case, it was decided in the High Court. So in the appeal, one of the issues was whether the Strata Management Act allowed a joint management body to impose different rates for different types of parcels in a stratified building. For the building is composed of three different aspects. One is the residential. The second aspect is the car park parcels, which is located on basement, level P1 to P6, and the also has retail units which is located on level 1 and 2. Here, the Court of Appeal held that the joint management body can only fix a single rate of charges to be applied to all types of parcels under sections 21 and 25 of the Strata Management Act. Another case which supports a single rate and also use the principles from Rajawali is this case of Chu Jin Hao, which we also mentioned earlier. So here, the parcel owners actually argued that it's unlawful for JMB to fix multiple rates for different type of parcels. The High Court, relying on Rajawali, established that JMB can only impose a single rate for all types of parcels. So in contrast to JMB period, we will now look at cases which were decided for MC periods. In the same case of Muhammad Nazri, the Court of Appeal actually indicated that in contrast to the joint management body, the MC is expressly conferred powers under section 60 sub 3 sub B of the Strata Management Act to fix multiple rates, but this is only limited to two specific situations. The first of which is parcels which are used for significantly different purposes or provisional blocks. For this situation, parcels which are used for significantly different purposes, we will see more clarity in this next case of IB Timbers Sdn Bhd. IB Timbers Sdn Bhd involved a dispute in regards to a mixed development known as Surya. If the attendees are familiar, Pearl Surya is located at Old Klang Road. There is the Pearl Surya Mall and there is also the residential apartments. For Pearl Surya, they have residential and the commercial parcels consist of the shopping mall and also the car park parcels. So the Court of Appeal held that multiple rates are allowed for parcels which are used for significantly different purposes. So here, the court viewed that the residential parcels ought to be charged one rate of maintenance charges on the basis that the residents in the residential units are allowed usage of swimming pools and also different common property usage than the shopping mall and car park parcels. So the owners of the shopping mall units and the car park parcels, they are actually not allowed to use the common properties such as the swimming pools. So here, that is the basis on which the Court of Appeal held that multiple rates are allowed because they are used for significantly different purposes. The leave application to the federal court was then dismissed. So as of now, the decision stands. We have another case, which is this Anand Perusan PD1 against SCP Assets Sdn Bhd. So over here, the appeal concerns a dispute over multiple rates imposed in a mixed commercial development project. So here, the Court of Appeal did not allow multiple rates because all types of parcel were commercial. So if you look at this case and the case of IB Timbers, the main difference is that in IB Timbers, the residential units, they are under residential, whereas here, everything is under commercial. So that is why the Court of Appeal came to a different decision than IB Timbers, even though both are mixed development projects. Next, we will look at one of the most recent cases in relation to single rate or multiple rate, is this case of Din against Perbandangan Pengurusan Spring Type Residence. So for Spring Type Residence, the development consists of apartments and villas. So the Court of Appeal did not allow multiple rates because both type of parcels are of the same use. They are being used as residential. For now, the latest update is that this matter is pending at the federal court. So I believe the federal court will be able to provide a much needed clarification in relation to the imposition of multiple rate of maintenance charges on parcels which are either of the same use or different usage. But on that, we will keep you updated. If you have any queries which are in relation to this case, feel free to reach out to our team. We will move on then to one of the main topic, which are the methods to recover arrears in charges. I believe most JMBs or MCs would have this issue whereby your owners or the parcel owners does not pay up in maintenance charges, be it individuals or companies. So we will look into the methods to recover them. So there's a list of methods actually. So usually a committee will start with publishing the names of defaulters on notice boards around the development. You will also see people restricting the access to the building, meaning anyone coming in or out, say they were to go into their parking, their accessory parcel, or they were to want to access their unit, they will have to register at the building, either at the security guard. So there's also the restricting of access or use of common facilities, such as restricting use of the gym or the swimming pool if there is a clubhouse. And then there is also another option document, which you can then discuss with the parcel owner for an installment payment scheme. And then finally, I believe this is the one that it ends with the issuance of a demand notice, either in Form 11 or Form 20 to the defaulter. So these are all methods which the management body does not have to go to court yet. And then moving on, of course, if the defaulter doesn't comply with the notice, management bodies will then either choose to initiate a claim at the Strata Management Tribunal. So this is where management bodies can actually go to the Strata Management Tribunal, initiate your claim there, a cost-efficient way because you don't have to hire in lawyers to help you with it. Or if the outstanding charges are above the threshold, then management bodies can then consider initiating a civil suit in the Malaysian courts. This is when you can approach us and then we can represent you in court to claim for these outstanding maintenance charges. There's also another option, which is a warrant of attachment, whereby you get an order for the seizure of the defaulter's assets. Okay, so moving on, we will look at some case laws for the notice of demand. So one issue where I've gotten some queries is that, can I, as a management body, can I just issue one form for all the parcels? Say the owners owns maybe 20 parcels or so. So here, the court actually held that the issuing a demand notice is mandatory, but the demand notice must be issued to each individual parcel. This is when it gets a little bit more tedious, but we will have to follow the court procedure. Other than that, I also get a lot of queries of whether can I turn off the electricity supply or can I turn off the water supply? Can I stop them from coming in? No, these are actually illegal methods. You should not be turning off the electricity supply or water supply to the unit. That is under the purview of the electricity department or the water department. And then another question is that can I prohibit them from coming in? So no, you can't actually stop them from accessing their parcel because the main parcel and the accessory parcel is theirs. So you can require them to register before coming in, but you should not be prohibiting their access to their own parcel. So what you can prohibit is their access to the common property, such as, like I said just now, gyms, swimming pools. Okay. One of the cases on illegal methods is this case of John Dennis De Silva against the Crescent Court Management Corporation. The parcel owner owed charges to the management corporation, and the parcel owner was subsequently prevented to enter the condo to park at his own car park bay. The management corporation also cut off the water supply to his unit. Here, the High Court held that clamping the water supply actually interfered with the parcel owner's enjoyment of the legal ownership of his own unit. The parcel owner has a proprietary interest and indefeasible title over his property, which would be the car park bay. So next, this is also one of the questions that I've always gotten, whether limitation apply to claims of outstanding maintenance charges. So no, limitation does not apply because it's a running account. It's incurred on a monthly basis, so there's actually no worries on limitation. And this is also established in case laws by the Court of Appeal, actually, in equity, where the management corporation filed a claim for the recovery of outstanding charges back in 2008. So the action was filed in 2016, which was more than 6 years from the date the outstanding charges accrued, which is about 8 years, I believe, from 2008. So the Court of Appeal here held that the management corporation's claim is a running account, and whatever charges not paid will be carried forward. So all in all, limitation. Another case is this City One Management Corporation. This is a High Court matter where the management corporation sought to recover unpaid charges all the way from 1997, November of 1997. And the suit was filed in March 2020, so much later. So here, the High Court held that the parcel owner's argument that the claim is time-barred was not successful as limitation does not apply. So the High Court here actually referred to the Court of Appeal case of equity certificate. Another topic is on recovery against companies in liquidation. So this is whether management corporations or JMBs are secured or unsecured creditors. So based on case laws, MCs and JMBs are actually unsecured creditors. So if the MCs or JMBs were to recover any sort of outstanding maintenance charges or sinking fund contribution, the MCs and JMB must file the proof of debt with the liquidator. So one of the cases which was decided by the federal court actually looked into this and also looked into the wording of Section 77 of the Strata Management Act. So the leave question posed was whether Section 77 of the Strata Management Act creates a preferred or priority status equivalent to a secured debt within the insolvency regime. So here, the federal court held that the word guaranteed in Section 77 of the Strata Management Act did not make the outstanding maintenance charges, which is payable to the MC, a secured debt. So at the end of the day, MCs and JMBs, they will rank the same as unsecured creditors, not secured creditors like usually the banks are. So another topic which we will cover today is recovery against successors in title. So what then can the MC and JMB do? Say if the company, the owner of the parcel, if it's a company, has gone into liquidation, then the maintenance charges obviously will not be paid. So what can they do moving forward? So here, the MCs and JMBs can actually recover these outstanding charges from subsequent purchaser or subsequent owner of the parcel. And this is pursuant to Section 60 sub 4 of the Strata Management Act or Section 45 sub 5 and 45 sub 6 of the Strata Titles Act. So there's actually a case, a Court of Appeal case, which discussed this. So over in this case, the MC actually claimed for outstanding charges accrued by the previous owners against the new owners of the parcel. If I'm not mistaken, the MC claimed for maintenance charges from the year of 2008 from the new owners of the apartments. So here, the federal court held that Section 44 sub 5 and sub 6 of the Strata Titles Acts are crystal clear. So a debt in respect of management fees are separately recoverable as debts from either the proprietor or its successor in title. In this case, actually, the MC claimed for about a year's worth of maintenance charges from the previous owner, which is Metroplex. This was prior to Metroplex liquidation. So after being informed of Metroplex's liquidation, subsequently the new purchaser, which is Bright bought the units quite a number of years later. And then the MC recovered the maintenance charges from the date which Metroplex was liquidated up till the latest date from Bright. And here Bright actually argued saying that I have not come in yet, I should not be penalized to pay Metroplex's outstanding maintenance charges. So here the court said, no, thanks to 45 sub 5 and 45 sub 6, the MC can claim against you. And because the MC filed a proof of debt for Metroplex's debt, so the federal court held that the filing of this proof of debt did not preclude the MC from seeking recovery against the new owners, particularly when the debt remained unpaid to date. So in this case, the MC actually claimed for one period from Metroplex and then the remaining period from Bright. So there is no overlapping periods of outstanding maintenance charges. We will move on to our next talk point, which is the usage for maintenance charges and sinking fund contribution. Okay, so what does maintenance charges cover? This is prescribed by the Strata Management Act. So it covers the security of the building, the property management and administration staff. So this would be the wages, which is required to staff the admin office, the electricity and water for common areas being the lifts, car parks, swimming pools, and gyms, the cleaning services, and also the wages of the cleaning crew, landscaping services, and also wages, the servicing of lifts and escalator, and also any minor repair works on common property. On top of maintenance charges, you are also charged what we call a sinking fund contribution. So sinking fund contribution is for capital expenditure, which includes painting of the whole building, the acquisition of movable properties, and also renewal, replacement of fixture and fittings. So renewal, replacement of fixtures and fittings are things like, say, if you were to replace the chain on your lifts, things like that. So how much sinking fund contributions are charged? So it is 10% of maintenance charges or any sum not less than 10% determined by the JMB or the MC for the period in which they were in control. No other charges. So in this case of Paris Tutamas, the MC sought a declaration that it was beyond its powers under the SMA to apply for retail license to take over the supply of natural gas. So the Court of Appeal here held that the MC is only permitted to collect maintenance charges and sinking fund contributions. The SMA provides no provisions for the MC to collect other charges for the supply of utilities such as natural gases. So it's very clear, JMB and MC, they can only collect maintenance charges and sinking fund contributions. So another case which looks at no other charges is Enda Parade, which is also decided by the Court of Appeal. Here, the MC claimed for unpaid charges for including signage charges, administrative charges for water meter reading, fire insurance, legal fees, and storage charges. Here, the Court of Appeal also held that MC can only levy payments which are mandated by the SMA. It will be ultra-virus for the MC to levy payments not sanctioned by the SMA. Another case, again, Square, where the MC claimed outstanding charges from a parcel owner by relying on a statement of account which included other charges such as utility and electricity charges. The High Court held that the SMA does not empower the MC to collect other charges such as utility charges. As the statement of account relied upon by the MC contained utility charges, the court found that the MC had failed to properly substantiate its claim. So with that, I will end my talk today. If you have any questions to ask, kindly post them in the chat box and we will address them. Rana, back to you.
Thank you, Reid. Okay, we will now be taking questions from the participants from the Q&A chat box. Okay, we have one question here. Can the sinking fund be set than 10% during developer managing period? Rachel?
So the question would be, can the sinking fund be set lower than 10% during the developer management period? So the answer would be yes. The timing where it cannot be set than lower 10% is after the JMB is established, because after that, then the JMB would have to follow the provisions of the Strata Management Act.
Thank you, Rachel. Okay, we have another question. Can the MC also impose interest charges on outstanding water and fire insurance?
So for this question, the MC can only impose interest charges on outstanding maintenance charges and sinking fund contribution. So these electricity charges and fire insurance charges, no, they cannot be imposing interest on, because these are all paid to third-party utility suppliers. So say electricity, you'll be paying to TNB, and then fire insurance depending on your fire insurance provider.
Thank you, Rachel. We just seeing the questions coming in here. Rachel, just give me a minute.
Yes, I think I see a lot of them coming in as well.
Okay, Rachel, we have one question here. Can the MC or JMB legally collect and retain rental income generated from common property? If yes, in which account should such income be properly recorded?
For this question, the first question, can the JMB or MC legally collect and retain rental income generated from common property? Yes, they can. And for your second question, in which account should income be properly recorded? Under the Strata Management Act, the JMB should have a JMB account. So any maintenance charges collected, any rental income, all of it should go into the same account. And it is for the JMB to ensure that there are proper record keeping for such income to the account, which is when you will get your audit report, etc., prior to your AGM.
Thank you, Rachel. Thank you. Another question here, Rachel. Can the MC prevent defaulters from carrying out renovation work?
So the MC actually should not be preventing defaulters from carrying out renovation work, because the renovations are being done in the defaulter's own unit. So as I mentioned just now in one of my slides, let me bring it up, the MC should not be disrupting the ordinary use of a legally owned unit. If you are a defaulter, of course, there will be a little bit of trouble in terms of coming into the apartment. You would have to register and things like that. So with that, then it may be a little bit more tedious for a defaulter, but they must let you carry out your renovation if it's within your own unit.
Perfect. Thank you, Rachel.
I think another one is on late payment charges. I did not discuss much of that just now. So whether the JMB or MC can impose late payment charges, yes, you can. I believe it is 10%. And these late payment charges is you're allowed 14 days to pay your maintenance charges. And then thereafter, the MC or the JMB has the power to impose late payment interest on however much that you are owing to the management body.
Are you able to take this one, Rachel? Can the JMB restrict access to common property, example, gym, against default?
Yes, I think I clarified that just now. Yes, the JMB can restrict the access. Say if your gym is in a room which requires access cards, so the JMB can disable your access card from scanning into that room. The JMB can restrict you from using the swimming pool, or certain developments, you have a clubhouse. The JMB can restrict your usage of the clubhouse until your outstanding charges are paid.
Yeah. Thank you, Rachel.
Kirba, I think we have a question from Catherine. I think this falls back to the examples I gave just now on claiming for outstanding maintenance charges against new purchasers, those who were accrued by the previous purchaser. I think Catherine's question is whether it works not just for companies, but also for individuals. The short answer is yes. So the Strata Management and the Strata Titles Act actually states that you can claim against successors in title. Successors in title would mean new owners, be it a company or an individual as a whole. So it does not draw a distinction between a company in liquidation or a bankrupt.
Okay, perfect. Thank you, Rachel.
I think we're getting a lot of questions on restricting access to the building.
Yeah.
So let me just clarify. They can't stop you into going into your own unit. But what they can do is that in usual situations that I've seen and heard of, is that they require you to register with the security guard. So you register, you get either a parking card, same as any visitor, and then after that you will go into your accessory parcel as you would. It's just the extra hassle of having to register. That's what I've seen happen. So in response to all the questions on restricting access to the building. So they can't stop you entirely. They can't tell you, no, you can't come in. No, it doesn't work that way. You can still go in, it's just that it's a little bit more tedious. I forgot, I think I've read one of the case. I thought of including it, but one of the case I read was the JMB actually stopped the person from using the lift, and the owner had to climb upstairs into his unit because lifts are considered common property. But I don't recall which case. If you are interested, feel free to contact me. I'll dig it out and I'll share it with you.
So I think you've more or less answered all the access questions.
Yes.
If you have any other specific questions, please feel free to reach out to us, and then we can give you a complimentary consultation addressing your specific issue or concern.
To all the attendees, if you do have any further queries which I've not addressed or which we have missed out, do contact us. You can drop us an email or whatsoever. The next few slides will give you some further contact information on how you can secure that complimentary consultation with us.
Yes. Thank you very much, Rachel.
Thank you, Kirpa.
Thank you. Okay. Before we conclude, I have a few announcements to make. First, please feel free to join us again for our upcoming talk entitled Medical Negligence, How Much Do You Really Know? This session will be conducted in Mandarin and will be on 26th of November 2025, Wednesday. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow or like our social media accounts. And fourthly, as mentioned by Rachel and I earlier, if you'd like to speak with our lawyers, we offer a complimentary consultation of up to 30 minutes over the telephone or over video conference. Please fill in the form on our website and the link will be posted in the chat box as well. Thank you very much for joining us today. We hope that you have found today's session informative and useful. Thank you again and see you at the next.